The next case is GUNN versus GUNN. If counsel will begin to get ready, please. Mr. Applegate, how much time do you want to reserve? 5 minutes.
Good morning. May it please the court. My name is Bob Applegate, and I represent CARA GUNN, who appealed a final judgment awarding primary physical residence of a minor child named Dylan, who was born in April of 1998. Probably throughout this, I will refer to CARA as Mom, and I will probably refer to Robert Gunn, the father of the former husband, as Dad in this case, because those are the terms that I use basically on a reasonable basis. The court entered a final judgment on February 11, 2004, awarding primary physical residence.
What is the relief that you're seeking?
Basically twofold, an either-or situation, a reversal, and a remand for an award of primary physical residence to the mom in this case.
Well, how are you entitled to that? I mean, I thought that your complaint was that the trial judge didn't go through and analyze, all the factors and make findings as to all the factors. I mean, isn't sauce for one? I mean, doesn't it apply both ways? How can we say, well, you didn't sufficiently analyze all the factors, but we're ordering you to give custody to Mom?
Or the alternative to reverse.
Well, I mean,
yes, Your Honor.
Let's get rid of number one. I mean,
Okay.
you're not entitled to that, right? All you're entitled to is, on your best day in this court, is a remand and us to instruct the trial judge to make more findings.
And have a hearing as to certain of the issues, or make more findings, yes, Your Honor.
Okay.
But to answer your question, I think this court, you just indicated to me, Your Honor, that I don't believe the trial court is ordered to, it's necessary to make specific findings to each one of those elements of 61.13.
You concede that?
Absolutely, and I conceded it in my brief.
And the weight to which each factor, is given is up to the trial judge, right? I mean, if he decides that 9 of the factors militate in your client's favor, well, 1 factor militates in favor of Dad, but that factor weighs so heavily in his mind that, that Dad should get custody, there's not a whole lot you can do about that, right?
I believe it depends on the factors in nature and quantity, and at that point we get to a situation which I feel is in this case, Your Honor, which is that the evidence may be overwhelming that it's in the best interest of the child that this child be placed with Mom in that situation. I think if you look at what this court did, first of all, we have the benefit of what this court did, because if he would have simply wrote out, we find in the best interest of the child, and we basically award it to Dad, I think we wouldn't be here, because I think he's entitled to do that. But here we actually see his reasoning as to how he got to those conclusions and the basis of his ruling. His ruling is not based upon the best interest of the child. He makes a conclusion that says that Dad is more equipped to follow share of parental responsibility. If you read and look at the trial court's reasonings, he ignored that whole gamut of factors in his conclusion that have to do with how the welfare of the child. He focuses on, in his order that he writes and tells us why he's ruling, on the issues really in marital issues between husbands and wives. By way of example, he finds that it is a beneficial thing that Dad has a good relationship with his fiance's child, although he condemns my client, Mom, for being upset that he's never home and not spending any time with the family. He shows that's a lack of commitment, share of responsibility, because she's upset that he's not home. That's an issue. Likewise, the court finds that my client, mom in this case, has an older child, which has a good close relationship, which the court doesn't really address with the minor child, Dylan. But he finds in his opinion that this child, the older child, the sibling has no relationship with his biological father. He finds that in favor of, a factor, negative factor towards mom. He finds it as a neutral factor towards dad. Well, but if you look at what happened and what at the trial court level and the testimony of dad in itself in this case, I think he comes to an opposite conclusion. First of all, number one is that my client absolutely promoted the relationship. The husband had contact and access. Dad had contact and access, visitation, if you will, prior to my client leaving for England, or for Ireland, at his desire, whenever he wanted. And that amounted to, and what did he want? He basically had the child one overnight in all of their separations, and he had the child for a cruise. The other thing is that as far as commitment, share, and responsibility, he would stop by periodically at his wife's house and see the child on a regular basis that way. She opened her doors to him. He came to her house on a regular basis. The duration of these visitations were an hour to hour and a half. That was what the husband testified. That's what Dad testified to. And in fact, Dad even testified that the night that my client returned to Ireland, that he came in and put the child to bed. Now, this is not a lady who is not committed to share her responsibility. This is not a lady, and the plain facts of this, is not one who basically is trying to throw up barriers between somebody. So while she's condemned.
Counsel, if he takes the child to Ireland without even telling the father and you keep him there, that's not a barrier to...
Yeah, Your Honor, if I may address that on two different levels. Number one is, the first level is my client testified that she bought a round-trip ticket. That is clear in the evidence that on a prior occasion, 2 years before in 2000, the trial court had entered an order that said that she could not take the child to Ireland. So my client goes to Ireland because she's fearful that she may not be able to get a respite.
Didn't that violate the court's order?
No, sir. There was no court order at the time. There was nothing pending at the time. There was no court order at the time. There was no restrictions about her. There was no pending dissolution of marriage action.
Sorry, I thought you said it before that.
There was an earlier one, and they reconciled. In 2000, these parties split again. They were separated for 4 months.
You clarified.
Dad went and got a restraining order. And it's interesting, in that restraining order, it says two things: that she's not allowed to take this child to Ireland, and also that she's an illegal alien, an illegal immigrant. So she's basically here at the whim of either her husband or some well-meaning person who can have her deported. I mean, so that's also in the background. But my client goes there. She buys a round-trip ticket. And when she gets there, we introduced this at trial, she calls him and lets him know where it's at. He's very angry, threatens to have her arrested, and basically cuts off all of her financial support. Basically, he tells her, that, and by these activities and situations, she's not welcome back at home. And in fact, by that November, by his own testimony, Dad's own testimony, he and his new girlfriend move in together in the marital home. So on stage one, there was no reason to come home, even though she had bought a round-trip ticket. On stage two is that she's an illegal alien. At any moment, the husband can have her, or Dad can have her call immigration and start the proceeding that could ultimately lead to her being removed from the United States without her child. So either way, there's a situation in which the conduct is explicable. We introduced.
She also started the proceedings in Ireland, didn't she, concerning the custody issue, and I guess she referred to it as the High Court of Ireland said no, that should be decided by the Florida court.
What the husband did in this case is invoke his rights under the Hague Convention. of which Northern Ireland is a member.
But I mean, she took the children, and I don't know that there's any evidence that she told them that she was taking the children.
And we'll concede there is no evidence.
To institute proceedings over there so that she can keep the children, rather than back over here in the United States. Isn't that what happened or not?
No, Your Honor.
Yeah, what happened?
I believe what happened was that the United States is a signatory to the Hague Convention. When the husband...
So when she went to Ireland, she did not institute proceedings
It's
over
my
there?
understanding she did not. He instituted his rights under the Hague Convention, which normally establishes which country is going to make an ultimate...
Is that how the order from the High Court in Ireland emanated from those proceedings?
Correct.
Instituted by, okay.
And the Hague Convention only determined where this ultimate decision will be made, which was Florida.
Oh.
So if we look at the negatives that the trial court used as the basis for its opinion, as far as the wife, we talked about the trip to Ireland, the situation involving it with reference to the issue with reference to the other child, which we've talked about. And then bottom line is that what we talk about is that she complained. She complained she didn't have a car. She complained that she didn't have enough money.
If we are to grant the relief that you request, aren't we basically going to have to reweigh the evidence and go through everything and basically substitute our judgment for that of the trial court, who I believe was Judge Angel? Especially when it seems to me that he, I don't know that he went out of his way, but there are statements in the judgment here that indicates that the primary concern is the best interest of the children. And, went through the litany of facts and circumstances and came to the conclusion that he came to. So I guess my question to you is, are we supposed to reweigh this evidence and take the decision away from the trial court? Or, and I'm trying to figure out, if we grant your relief, what else are we supposed to do? How else do we come down on your side in this case?
Well, as I had indicated in my brief, to answer your question, I'm not asking you to reweigh the evidence. That's certainly not what I'm saying. I'm saying read the court's opinion, look at the logic as to where it's got. Notice that there is no finding, and in fact, the court really went out of its way not to make a finding as to the best interest of the child, substituted an alternative standard on paragraph O, in that it says that finds it demonstrated the best understanding of and commitment to the concepts of shared parenting. And then based upon that standard that he created, which is not a statutory standard.
Let me try to phrase the question. Maybe I'm getting at the same thing that Judge Savoy is getting at here. I think you already acknowledged that we can't reverse and order custody in favor of your client. I think you've already acknowledged that, right?
I've acknowledged that. I think there's law in Florida that says you can do that, which I cited in my brief.
Really? Okay, right.
They say, well, the evidence is overwhelming in favor of one and not of the other, that the court, that the abuse of discretion or the grant of discretion of the trial court is not boundless, and that when it's overwhelming in one, and I believe, and as I pointed out in my brief, I believe it is overwhelming, but, honest to God, this court can judge that by itself, but, I mean, because even if you really closely read the trial court's decision, and especially look at what's been omitted and included, you come to the conclusion.
Right. Let's assume that
okay.
that I disagree with you on that, and that we can't just take it away from the trial judge altogether. Then we're left with the task of correcting legal error, and on remand we have to tell the judge, this is how you erred, and this is what you need to do in order to correct it. Would you answer those two questions for me? How did he err, and what is he supposed to do to correct it?
Okay. In order to make a meaningful review, I believe that number one is that he needs to use the standard of the best interest of the child. Okay, which he did not use that standard. He used the standard.
He did say in here that the best interest of the child. There's language in here about the best interest of the child is served by joint or by shared custody.
And also, in addition to that, it says in paragraph F, this being the initial custody determination under 6113, the court is to decide what is the best interest of the child, and then it goes on with paragraph F and all those findings. So I guess maybe you can answer Judge Floyd and Judge Torpey's question now, based on those statements in the final judgment indicating that that's the primary issue he's trying to decide.
Okay. Let's read his own thought processes. And his own thought processes.
We're not going to get involved as an appellate court in going through the thought process.
No,
what
but
we're going to look at is whether or not there's any fact that he's found that isn't supported by any evidence whatsoever. That would be an error if he found a fact that simply doesn't have any support.
What I'm saying to you is that if you read what he said that since the parents have foreclosed what is in the best interest, he doesn't address the best interest. He doesn't address those factors in his opinion. Once you start to go down that factor, the only ones that I believe he actually addresses are basically the mental health of the problem and that they love the children.
But counsel, is there any fact that Judge Angel found in his final judgment that you maintain is not supported by evidence in the record? Testimony or whatever. Is there any fact that he's
Absolutely not. Every fact there, the conclusions aren't supported by the facts that he makes, but that's a mental process, and I understand that.
Yeah.
And I think that if you
can understand the dilemma we're in, we may feel like he made a wrong decision, but we can't. That's not our role, is to substitute our judgment for that of the trial court.
And I'm not asking you to do that. I'm saying that when he says in his final judgment that I'm using the commitment to share from responsibilities as the basis for making a determination of primary fiscal residence, that's an error. And I believe that's not what the law is, and it ignores a significant body of 61.13, and that is the reversible error that I'm asking that this court correct. And I know I'm at 447, so.
Counsel, let me get this. This thing is not performing correctly. You may begin, sir.
Good morning. If it may please the court. My name is Ron Cole. I represent the father, Robert GUNN, in the lower proceedings and in these proceedings. And I think this case, what's important to look at right off the bat is that it had giant implications. It wasn't your standard custody case. The mother had a 10-year ban on her where she could not return to the United States.
Are you telling us that this ban that was entered originally still applied when she took the child to Ireland?
Absolutely, Your Honor. And even more so, opposing counsel keeps referring to her buying a round-trip ticket like she had intentions to come back when she fled to Northern Ireland. Well, a month and a half before that, she had round-trip tickets to go on a Bahama cruise. The port authorities there told her, and this is in the record, that if she leaves, she can't come back, she'll be deported to Northern Ireland. She knew that. She was on notice that if she ever left voluntarily, she could never come, not never, but she couldn't come back for 10 years. Despite that, despite knowing that, she made a decision to leave. So here's where the big problem comes up. When Judge Angel got this case, he realized that if he ruled in the mother's favor, the child was going to Northern Ireland to live, because mother could not stay here under any circumstances unless somehow she worked out her problems with the immigration. If he ruled for the father, the child's going to be an American. So they're going to be an ocean apart no matter what happens. So he had to then look at the facts and the evidence and try to make a determination with what's in the best interest of the family. And he did, I think, a good job. If the main thing that he cites, and it happens to be in 61.133, the first thing they talk about in A is the parent who is more likely to allow the child frequent and continuing contact with the non-residential parent. That is enormously important in this case because they're going to be an ocean apart. Well, he looks at the facts and he sees that mom fled in the middle of the night, didn't take any toys, abandoned the car at the airport, knowing she could not return, and she did nothing while she was gone for a year to attempt to encourage visitation or let the child come see his dad or any of those things. She didn't do anything, and she certainly didn't initiate any proceedings to try to get a determination. On the contrary, the father filed a dissolution of marriage petition, and if you probably recall that in this case there was a dissolution of marriage hearing without the mother there. She didn't attend, and there was an order entered in the father's favor, and it also found findings of fact that it was in the best interest of the father, of the child, for the child to live with the father. Well, she was over there, so that didn't do a whole lot of good, and so he initiated and made application to the Hague Convention and requested their assistance. This was successful, and they ordered the mother back. Now, there's another sort of a odd curiosity thing that may mean something that you guys, or excuse me, your honors could figure out. Mr. Applegood, after the hearing went for 2 days, and timely, and he notes in his brief that he timely filed a notice for rehearing, which is correct. But he doesn't tell you, and he tells you when it was ruled upon. But he doesn't give you the dates. It's set for 1 year. For 1 year, it's set without any hearing on it. So there's no urgency to do anything about this, or there would have been a hearing before a year. The hearing was back in 2003, and now we're at 2006. The father he was in the military, he followed orders. He convinced the judge that he would follow the judge's orders. And he even said on the record, if you tell me the child's going to Ireland to visit, I'll do it. And I think he's sincere, and I think he proved that to the judge. And the judge makes that finding of fact in the second order was called the custody decree. The first one was a final judgment of dissolution of marriage. And everyone conceded at this 2-day hearing in November of 2003, the only issue would really be where the child's going to live permanently. And the judge made it, in his custody decree, he made a finding that it was more likely that the child could continue to have frequent contact with everyone if the father had custody. I think the other element that he looked at was in 61.133B, the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. The child, if you look back at the facts, you see that he was in the service, they met in 95, they got married in, I believe, 97. The child was born in 98, and the child came to the U.S. This was a joint decision because he wasn't making much money in Northern Ireland. They were having a rough time, and they made a joint decision to come to the United States when the child was 8 months old. The child lived here from 8 months old until he was 4, I believe, just when the mother decided to leave. His whole life he grew up in the United States. He had friends, he had roots, he had the father's family. He had a lot going for him. And I think that the length of time that he's lived in a stable, satisfactory environment comes into play. And there's evidence to support that in the record. I don't believe they can meet their burden showing any abuse of discretion. There's certainly competent evidence to support these issues that I'm bringing up in the record. There's a presumption of correctness, and I believe that there's no reason not to presume it's correct to start out with. And it looks to me like there was one other issue that he brought up about splitting siblings. There has been case law dealing with that, and the 5th District has supported splitting siblings before also, usually when there's a compelling reason. And there was a compelling reason in this case to do that, and that was because the ocean apart between the two families. You have to consider the mother's conduct. We believe, or I think the evidence shows that she created this problem. She made a decision to leave, and once she did that, there was all these consequences that followed. I would sincerely ask that you affirm the decision. Judge Angel.
Thank you.
Briefly, the child was performing well in school. The child was performing very well in school in Ireland. Mom was, and if you read the judge's opinion, Dad was always out working. Mom was the one that raised his child. Mom was the one that made the child who he is today, and basically the child was a student of the month when the child was in Ireland. All the child's met the needs were met, and basically the child was going home where there's an extended family where these people initiated their relationship. So the bottom line is that factor certainly is it certainly would mitigate heavily in favor of the mom in this case. The reason, and I believe you read it contextually, the context of where the court's finding relative to the facilitating the contact and access is because of the husband's superior financial ability, and the court says that in the final judgment. And he does have a superior financial ability to the situation. Whether or not she goes or is sent there, I believe under the facts and circumstances of this case, I think that it's certainly legitimate to conclude that this lady is going to end up in Northern Ireland, whether or not she's being taken there by Immigration and Naturalization Services, or on the alternative, whether she voluntarily goes, because the court previously found, as introduced at trial, that she was in fact an illegal alien. So that issue certainly is one that basically is going to happen. It's not an intentional situation in which we're going to go somewhere and thwart. She cooperated with the. We're not going to thwart contact and access, and we're not going to thwart the relationship with the father, because when the child comes back, he's got a great relationship with his dad. And there's one person who did that given the time, and that's mom in this case. My client followed every court order that was ever entered, voluntarily returned to the United States, underwent a trial on a very limited notice, basically with limited time in order to get there. And so the bottom line with reference to that is that, and plus the additional situation is that so many countries basically don't ignore custody issues. We know that the Northern Ireland does follow and does enforce and does protect people's rights, and she was aware of that too. So, Your Honor, that's basically the situation with reference to that. I don't know specifically that there was a specific introduction at the trial of a 10-year ban, and the delay in filing the motion for rehearing were probably for reasons that are not in the record and certainly are compelling, but not before this court. The father had a great relationship with the child. The father has a ongoing good relationship with the child at the time, and basically saw the child as and in what manner in which he desired to see, and there was no evidence whatsoever that there was any impediment to this man seeing his child prior to leaving Ireland, and there's no evidence at the time period when he returned from Ireland. So, Your Honors, we believe that the court used the wrong standard. We believe that matters should be reversed. Thank you very much.
Thank you.